remedies of Malaysian law on contract law. The reasoning is the class was not recorded, so I have to do a recording on this as it's an important chapter, so that we could cover this chapter here today. I'm hoping that this video would not be over an hour long. So that's the plan. So I won't be spending too much time with introduction. So I hope you enjoy this video and this elaboration, and hopefully it helps you with your revisions moving forward. All right. Okay. Let us share our slides right now. Yes. And here it is, the slides. Okay, remedies for breach of contract, Malaysian law. So this is, of course, covering contract law 2, diploma in law, Segi College Sarawak, part of the Hertfordshire University bachelor's program. All right, moving on. These are several of the remedies present for breach of contract in Malaysian law. Now, you of course should check your notes and read your notes. The slides are a summary of the notes. They're by no means the full detailed version of it. So again, you should do your revision through your notes. But here are some of the remedies that you could put up in if the exam comes in with a question concerning breach of contract and what are the possible remedies for it. The first one, the most common type, and the ones that often people sue each other upon, would be damages. Damages are very simple. I hit your car, you need to repair your car. Now you're of course claiming damages from me to repair your car, as if your car was not hit by my car in the first place. So those are damages, are very simple often. Often they are basically what people often sue each other on. And then the second one would be specific performance. This is pretty interesting. This is where a particular party requests another party, normally the person that they contract with, to actually complete the contractual obligation by requiring them to do a specific performance. The court, of course, can request these parties to do make them actually, not request them, make them perform the specific performance. Oftentimes, this concerns the contractual obligation in the first place. For example, if you're supposed to supply 100 kilos of rice to Everrise and you don't, Everrise can, of course, ask for specific performance for you to do this. Now, there could be many reasons for this. Instead of asking for damages, one, it may be very difficult to find suppliers. In which case looking for suppliers may take too much time and may actually be more costly than the amount of damages they may have already suffered by you being late, perhaps, on sending your 100 kilograms of rice. An injunction here is stopping someone from doing something. Oftentimes, this is at the time, what do you call it, during the time of the trial, of course, insisting they should not do something. Perhaps they shouldn't sell to your competitor or something like that. That is an injunction. A quantum of merit, which we're going to take a look at later. This is something quite unique to Malaysia, so you probably would want to take a look at that. There will be more detail later on. Rescission, of course, you already know this from UK law. 1, 2, 3, and 5, you already know from UK law. Malaysia has a unique quantum of merit situation, but rescission is quite common. This is basically you end the contract. Oftentimes, you're also asking for damages as well, basically ensuring that both parties have no more contractual obligations to each other. All right, so damages. The measure of damages is recoverable under Section 74 of the Contracts Act 1950, in common law, as stated here, in the judgment of Anderson B. in Haley, Anderson B. in Haley and Baxendale, the rule is that the injured party is entitled under Section 74 sub 1 damages arising naturally from the breach, and Section 74 sub 1, if one claims special damages, the party must show that they entered to the contract and the other party knew the special loss likely to resolve the contract. The word special loss is a very interesting situation. This basically means perhaps you have something unique, like let's say you lost a contract because this person was unable to send the supply, or you lost reputation perhaps. Those things are possible special losses. Section 74 sub 2, such compensation is not given for any remote or indirect loss or damage. Now, remote damages, obviously, you shouldn't claim them. Indirect damages, you also shouldn't claim them. These are things that are indirectly caused by your failure to, the breach of contract by the respondent. In this particular case, of course, the respondent, because the claimant is, of course, claiming for the breach of contract in that particular case. So if it's indirect loss, indirect damages, most likely you cannot claim them. Yeah. Okay. Section 74 sub 3 of the Contracts Act 1950. When obligation resembling those created by the contract has occurred and has not been discharged, any person injured by the failure to discharge it is entitled to receive the claim compensation for the party in therefore as if the party had contracted to discharge it and had broken his contract. Meaning here, in very simple layman terms, it literally means that you, of course, can ask for compensation and damages for the failure of that person for carrying out their contractual obligations. It's as if they had carried it out, and the value of the damage would be roughly like that. So, for example, you are made a loss of $10,000 because you had to give some refunds to your clients because, for example, maybe your pizza did not arrive on time and things like that. Okay, that's a very odd example. Okay, let's give an example in this particular situation. Let's say that you are a bit tough. Where would this be more simple and very obvious to cite? All right, let's say that you are a shop that sells football. Okay, you sell football. Football by or the Americans call soccer, but in this particular case, football, the ball itself. So you're selling football, and that football is very specific to the Euro championships in 2020. So it's a very time sensitive football, meaning that it should only be sold during the time of the Euros, meaning that it's more likely to be very profitable. And let's say people have already booked it from you. You are middleman. You don't actually create the football, but you are middleman. You are a supplier of the football to customers, perhaps from your shop. Now, let's say your supplier fails to deliver the football on time, right? And now, because they fail to deliver, the football is only available after the Euro is over. Obviously, the people buying the football will be less ecstatic about that and probably would want a refund of their football. Maybe not all of them, but some of them would. So in this particular case, you can ask the damages for those who did ask for a refund. You have to pay them off with your own money because, of course, your supplier was late and had breached the contract or being unable to fulfill your orders in the first place. So whatever money you've refunded to those clients, obviously, who have to return the money and all that, this is obviously no good. And you can claim that damage from your supplier as he has failed to deliver his part of the contract, which was the football on time, so that you can sell them to the end customer. All right, so that's an example. Okay. This means if possible for third parties and beneficiary to be also able to claim damages from the party in the breach. So this is also interesting. In this particular part, normally in contract law, a third party can't sue because they're not really part of the contractual obligation. But in situations in Malaysian law, it's allowed under Section 74 sub 3 Contracts Act 1950. So they are allowed to claim for losses from you. So meaning perhaps the customer themselves could actually sue the supplier. That's also possible. And of course, you, the middleman, can claim on their behalf as well. So this is something that is allowed in Malaysian law, which is very unique. In some cases in UK law, often third parties' rights cannot be enforced. Very rarely could be, but there are situations that can, but we will not go through that as this is not part of our chapter. Okay. The case you want to take a look at, you can find that on your notes, is Tao Chou To, Associate Metal Spears Metals. This is, of course, the case. Always remember that every statement must have evidence, and you must, of course, state the case law after you have put out your arguments forward, always put them in. Section 75 provides if the amount of damages is stated, penalty is stated in the contract itself for the breach of the contract, the amount recoverable of the plaintiff cannot exceed that sum. Let's say you already signed an agreement with your supplier of the football just now, and let's say, I don't know how much football costs. I'm going to assume it's roughly around £50. And in this particular case, you say if you fail to deliver it on time, you'll be penalized £48 for each football. Meaning here, if you already stated in the contract itself the penalty for your supplier not to fulfill his contract, the courts will enforce that penalty. They will not give you more than that. After all, you're the one who agreed to the penalty in the first place. You're the one who signed the contract. Then the courts will enforce that even if your cost is actually more than the penalty you stated in the contract. This is also the reason why oftentimes when people make contracts, the penalty is almost always more than the possible cost or loss that they would incur if the contract is breached. For example, the Vampire Lestat, I think the movie was the Vampire Lestat, or which is an Anne Rice vampire movie. I'm not quite sure if that's the correct name. Anyhow, Brad Pitt was in the movie, and he didn't like being in the movie. He wanted to get out. The problem was he had a contract which states that if he breached it, he would have to pay $20 million. Now, that may seem very little for Brad Pitt today, but you have to understand this was Brad Pitt at 1990s, and he was still at the early stages of his career, and by that time was not a bona fide superstar yet. You may even argue that by even today's standard, $20 million is quite a lot for even someone who is a bona fide superstar. I mean, I believe the payment to an actor is roughly around 30 million, 40 million for per movie, unless of course we're talking about Marvel movies, which is slightly different. Anyhow, there's still a lot, and obviously Brad Pitt could not breach his contract because then he would have to pay the penalty of $20 million, $20 million, sorry, $20 million, which is around 10 or maybe 15 million pounds. So in this particular case, he had to keep acting in the movie. He did a pretty good job. It's not obvious that he didn't like the movie at all or didn't like to be acting in it. But anyhow, this is basically it. He can't breach it. And if he did, he would have to pay the producers £20 million. Claim for damages and restitution money paid to the party in breach. Okay, so claim for damage, restitution of money is paid to parties in breach would, of course, I mean, you always have to pay the person who did not breach, the innocent party. In Yang Mong Hin United Malay Sugar Industries, the appellant building contract abandoned work on site, and so the contract was voidable adoption or respondents which they exercised rightly. And of course, they could claim the damages. For breach of contract, the innocent party can claim damages, obviously. Now, you can't claim the penalty for your own breach. That's ridiculous. For example, you're the one who did not complete the building, as in this case. You can't say, oh, yeah, I have to enforce the penalty on you, the one who actually did not do anything wrong. That's ridiculous. Obviously not. Only the innocent party could actually claim for the penalty amount under Section 75 in the contract. When you're practicing in the future, you will see these terms. They will be present in a lot of contracts that you will be doing. I mean, if you are a Malaysian, for example, I'm sure there's no difference if you're of another common law country, perhaps, then you probably will be seeing these so-called breaches in the contract. A penalty for it if you fail to deliver your part of the bargain, in other words. Section 76 of Contracts Act 1950 states, a person who rightly rescinds a contract is entitled for compensation of any damage which he has sustained throughout the non-fulfillment of the contract. In addition, if the innocent party rescinds the contract, the other party did not perform the contract any further. However, the innocent party must restore benefit received to him to the other party. Let's say you receive some of the benefit, but not all. Let's say you are ordering 1,000 kilo of rice per kilo. Okay. Let's say you ordered 1,000 footballs. Okay, footballs, the ball. And they're supposed to be sent to you within like 2 batches, 500 in the first batch and another 500 on the second batch. If you are rescinding the contract, let's say you already received the first batch, you will have to return them back to the supplier, despite the fact that you might want to keep the 500 balls. You have to return everything, and he of course will have to return your money that you paid for those balls. So a lot of balls discussion apparently here, yeah. Section 65 of the Contract Act 1950 states, when a person does option the contract's voidable since the other party thereto did not perform any promise to obtain, which is the promiser. Now, of course, you are breaching the contract, and of course the person rescinds the contract, but this also means that you don't need to send the other 500 balls of the second batch, which you were supposed to send, but you didn't. Maybe you were late by a week or two. In this particular case, you have breached the contract. So again, I understand this can, of course, go to denominate terms whenever you lost the whole cost of it all. These things are none of our discussion for this particular chapter. I understand there's a more expansive chapter, which we'll probably cover at a different time. Now, what we're going to talk about here is that the fact that if you get rescinded the contract, you don't have to perform the contract any further. Even if you're the breaching party, you don't need to fulfill the rest of the contract once they rescind the contract. Let's say you were supposed to send 3 batches of football and you already sent 1. You don't need to send the 2 and the third one, and because then they will have to just return it back to you and you have to pay them. It doesn't make any sense. So in this particular case, the court will not require to do so. The party rescinding the voidable contract shall, if you receive any benefit thereto, the party such contract restore the benefit, as stated before under Section 76 as well. So this is a rehashment of that moving forward. When the innocent party rescinds the contract is avoided by him or her. Obviously, if you rescind the contract is voided by you. Okay. Section 66, when a contract becomes void, any person who has received any advantage under the agreement or contract is bound to restore it or to make compensation for it to the person whom he has received it. Now, there are other situations where other people may have received benefits from the contract. For example, the football might have been given to other customers. They will also have to return that ball perhaps. But of course, it really depends on the situation. Customers very rarely are affected by businesses unable to deliver from each other, but sometimes other businesses get hurt by it. Okay. The case we want to take a look is Kabatan Timber Extraction Core and Far and Sing. Now, of course, I put this case here because it's quite interesting. The court held it was the duty of the respondent to take reasonable steps to mitigate the damage caused by the appellant when he failed to deliver the logs to the mill but left them some 50 feet away. So this supplier of logs is very cheeky. So he actually sent the logs to the mill, but he put it 50 feet away. That's less than half a football field. I mean, that's it's literally half a football field, perhaps. It's 50 feet, the same with 50 meters. Okay, never mind. Attack me in the comments if you want to. Anyhow, they're very cheeky. They put it 50 feet away. You could literally see it. It's 50 feet away. Instead of sending it to me, they just drop it 50 feet away. In which particular case, it's like the biggest, middle finger to this person, to be honest. And obviously they were not very happy. So they of course claim for rescission of the whole contract. So basically what they want is that they want these people to take back the logs and pay them the full amount of payment that they've already paid for the logs in the first place. The court said there is no need for this. There is no need for the respondent to have gone to the expense and trouble of buying from elsewhere when the logs were lying literally a few hundred feet away, actually 50 feet away, and all was required was additional expenses for hauling them up to the sawmill. The damages were awarded for the respondent for failing to meet the gate and reduced accordingly. So the court said, no, you can't ask for your full payment back. You can't ask for the full payment because they did send it, but they sent it only 50 feet away. So instead, you can claim maybe part of your money back. For example, the amount needed for you to lift the logs from that 50 feet to your mill. So let's assume that property costs around, let's say the whole contract costs around $1 million, and let's say the cost of lifting it 50 feet to your mill is around maybe £100,000. In this particular case, you can claim from the log supplier the £100,000 needed for you to haul them to your sawmill, as they of course should have sent it to your sawmill in the first place. So they of course should pay for the cost that they have created for you because you need to lead, you now need to lift the log 50 feet. Now, obviously in the real world, this does, I mean, in theory, it does sound nice. You're going to get your money back, all that, and all your expenses will be covered. But after trial and all that, you're probably going to make a few losses. So the £100,000 you're going to claim for them actually is much less than that after you deduce your legal fees and all that. And it's possible that you can ask them to pay for your legal fees if you win the case. But again, this is no certainty, and oftentimes you will never get your full damages paid. So I would say that perhaps if your loss was around £100,000, you're probably going to lose at least £30,000 for this person not actually carrying out their contract. And of course, you should basically stop making business with these people because how terrible they have treated you. Okay, now, let's talk about specific performance. Specific performance is another form of remedy that the courts in Malaysia can, of course, give to you. Specific performance, of course, requires someone to do something. Specific performance will be granted when damages are not adequate remedy. Now, normally the courts want to give damages. They're not comfortable in asking another particular party to do something that they wish not to do. However, there may be times where specific performance may be necessary, so damages may not be adequate for it. Okay, so under Section 21 sub 2 SRA provides some situations where the court shall not grant specific performance. One, when they give an unfair advantage over the defendant. So meaning that if they give the specific performance and insist upon it from the defendant or the respondent, this will create unfair advantage for them, meaning that on the claimant, on the respondent, which is of course the court do not want. When the performance of the contract would involve some hardship on the defendant which he did not foresee, and non-performance would be such hardship to the plaintiff. Will be no such hardship for the plaintiff. So here, basically what it's saying is that if there's some form of hardship that will be caused by forcing the respondent to actually carry out the contract, that he could not foresee. Perhaps he did not foresee how costly the contract would be. Maybe he had miscalculated. In this particular case, the court will not grant specific performance if the claimant, now this is the very important thing, if the claimant did not suffer any hardship at all. Okay, so meaning that if the claimant did not suffer any hardship, but the respondent will, if they had to carry out the contract, then the courts will, of course, not enforce it. But if the claimant does suffer from hardship, due to the respondent not performing the contract, and in that particular case, the court will allow specific performance. Now, it's very rare the claimant doesn't suffer from any type of hardship if the respondent breaches their contract. Very rare. I mean, the obvious situation is that in a contract, there is a need of both parties to do what they promised to do. That is, after all, a contract. If you have suffered no hardship at all, if someone breaches your contract, then there's really no need for it in the first place. So it's very rare that there is no hardship on the claimant. So the courts will often have this little problem in enforcing specific performance on respondent just because they suffer from hardship, because normally the claimant will also suffer from hardship due to them breaching the contract. Okay, Section 18 sub 3 of the SRA gives the power to the court to award compensation in addition to specific performance if the specific performance is not sufficient to satisfy the justice in the case. Now, this is relatively left quite vague, mainly because the court wants to allow for situations where maybe specific performance and damages may be necessary at the same time. Section 11, Specific Relief Act. So, of course, when we talk about SRA, we are referring to, of course, Specific Relief Act. When the party agreed to be done in performance wholly or partly of trust, okay, when the party exists, no standard of settlement of the actual damages caused by non-performance of the agreed to be done. And C, when the agreed is done, the petitionary compensation for its non-performance will not afford adequate relief, or when it's probable the petitionary compensation cannot be done for non-performance of the agreed to be done. Okay, so number one basically means this: in the performance, it is a performance of trust. It has to be done. It depends. The party depends on the other party to actually carry out the contract. It's of one of extreme trust. The court will often allow for specific performance. B, where there is no real way to know what is the cause of them not performing the contract. Okay, here's a good example. Movies. Okay, let's say I hired your production company to do a trailer of my movie. Let's call it the Living Squad. Okay, the Living Squad. I hired you to do the trailer. It's supposed to be done 8 weeks before the movie's release. Let's say you don't deliver 8 weeks before. Instead, you are late delivering it, maybe only 4 weeks, or dare I say even a week before the trailer, before the movie comes out. So you don't really know what is the cause of being late for 5 or 6 weeks. You don't really know, because movies, again, are uncertainable. Who knows if the Living Squad would be very successful or not? Who knows? Movies who people expect to do very well tend sometimes don't do very well, and movies who we think that are not going very badly actually does very well. So we don't really know that. So how much does the trailer provides in terms of value is understandable. So due to this situation, the court may want the person to just finish the trailer and carry out the contract, because again, you don't really know what is the actual damage of that possible trailer being released, being not released, or released very late. You just don't know. So instead, you just insist upon them carrying out the trailer in the first place. And of course, on the third part, it will not afford adequate remedy. Again, the same argument can be said of the trailer. Payment may not be enough. You may want also the person to actually carry out specific performance. So how hard is it to find a new production house to make trailers for the movie Living Squad? Obviously, this is not good. That is no good, because if you have to find a new production house, you have to get them to do the trailers, they have to edit it. It takes a lot of time, and it may actually be worse than actually, just simply asking these people to complete a job that they may be late in delivering, but better than actually finding someone else, which can be quite tough. I mean, to be honest, for someone who actually has tried to actually just make a poster of an event, this can be really tough to find someone who could deliver in a short period of time. Okay. Section 18, sub 3 SRA gives the power of the court to award compensation in addition to specific performance, so they can give both if the specific performance is not sufficient to satisfy the justice of the case. So the court again can give both a specific performance and also damages. Now, oftentimes the court will do this if, just like the trailer situation, where it's such a gross misconduct, such a gross breach of contract in one situation. I mean, you're supposed to deliver the trailers. Trailers are very important movies, and due to this reason, you are not able to deliver them. The court would often likely, of course, provide damages as well as specific performance to try their best to mitigate the loss suffered from the person who hired you to make the trailer. And I'm not referring to you, but of course, it's easier for you to understand it if I explain it in that way. I'm sure everyone would carry out the contracts to the point here. I mean, you all are future law students after all. Okay, Section 11, sub 2, Pacific Relief Act 1950. There is a presumption, unless the contrary is proven, that the breach of contract to transfer immovable properties cannot be adequately remedied by damages, and thus specific performance will be granted. Section 11, sub 2 is presumption which is rebutted to contrary to the intention. So again, you can rebut this intention. Okay, so when you're buying properties, most likely you want the person to sell you the property, right? Damages, particularly of no concern to you, you don't really particularly care for that. You want the property to be moved to you, transferred the ownership to you, like a castle or house. I immediately go to a castle, is really weird. But like a house, a hotel, a shop, you probably want them to actually carry out the sale instead of like paying back your money. In that particular situation, maybe you really want to buy that house, you really want to. In this particular case, there is presumption that if it comes to immovable property like a home, they will enforce a specific performance, unless, of course, that intention can be rebutted, meaning that the court will assume that it's not adequate to just pay your money back when you're buying a house. Maybe you already prepared your life to move or things like that. That's obviously not good. I mean, if you quit your job in a different city, thinking that you're going to move to a different fam and you already have a home, all these things would be very problematic. So the courts, of course, would assume that damages is not enough, but this can be rebutted. For example, perhaps the home is not very important to you. You are not in any hurry to move, or maybe this is you purchasing the 10th house. That's really obviously not. I mean, you don't really need the immovable property. In which case, the court can just not can just give you damages. Oh, you still get damages. You still get something back, but you probably won't be, specific performance may not be enforced. The case you want to take a look at is the Kufri Musa and Faisal Khanam Ashad Khan, 2015. At any time in this lesson, you can of course pause. Please do if it's too much. Take a minute. I can't stop. I mean, this is one recording. I have to continue on, but you definitely can pause, take a break, drink coffee and come back and then continue it. Or you may stop here and then tomorrow take a look at the recording yet again. But remember, finish what you started. It's like exercising, you should do it. Why am I telling people to exercise? I myself is overweight, God knows. Okay, injunctions. Injunctions are a bit different. Injunctions is when you tell someone not to do something. Pacific performance tells someone to do something. Injunctions is the opposite. They're telling them not to do something. To stop them from doing something is another thing. Injunction is an act to restrain someone from doing something or requiring someone to perform an act, weirdly enough, which may often lead to specific performance. But when they say requiring someone to do a specific act, what they mean here is they're trying to restrain that person, but to restrain them, that person has to do something. So it, of course, forces them to do something. Granted, this is in discretion of the court. It's always the case. I don't know why people would just say that. It is to be granted in discretion. Everything is in discretion of the court, to be honest. So anyhow, let's move on. And Section 50 Pacific Relief Act 1950 provides preventive relief is granted by the court, either temporary or perpetual injunction. Okay, now temporary injunctions are doing the trial itself normally. So also known as interim or interlocutory injunctions. Goodness, am I saying that right? God knows. So anyhow, just say it's interim injunction, temporary injunction, make your life easier for yourself, yeah? It is granted at the discretion of the court for a specific period of time until further ordered by the court, as stated under Section 51, Sub 1 of the SRA Special Relief Act 1950. Okay, the case you want to take a look is the American Settlement Institute, where they, of course, state the temporary injunction. Oftentimes, this is only during the trial, and until the trial is over, that injunction may be lifted. It also, of course, depends on who wins the trial as well, whenever the injunction is lifted or not. This one is more interesting. Perpetual injunction, obviously, what does perpetual mean? It means forever. Forever, to my knowledge, is quite a long time. So, also known as a permanent injunction, yeah. So you're stopped forever from doing something. It can only be granted after a full trial, meaning that you cannot be doing the trial itself. It has to be done after a full trial, and then the court can instill a perpetual injunction. Normally, the court will state a temporary injunction when the trial is going on, and after they decide everything, they may call for a full injunction to stop someone from doing something. The defendant is permanently prohibited from doing an act or asserting a right in which the injunction was granted, as stated under Section 51, Sub 2, SRA 1950. Moving on, Section 54, F. An injunction cannot be granted to prevent a breach of contract, the performance of which could not be specifically enforced. So you can't use an injunction to prevent a breach of contract. You unfortunately actually have to wait for the breach and then, of course, sue that person on that breach itself. This is found in Permata, Cabaret Night, and Roman Tam. This is a very old case. I know for a fact because we very rarely have cabarets here in Malaysia nowadays. I think they're a thing instinct nowadays due to some moral fear about it. Lumley Wagner, Wagner. Lumley and Wagner is also another case you want to take a look at when you are talking about perpetual injunctions. Both cases, of course, talking about when it's necessary, when is it necessary. But all the thing you need to know is that this is one of the remedies available to the court if the injunction is necessary in the first place. Okay, quantum merit. So quantum merit is, of course, pretty interesting. This is very unique to Malaysia. Here it means that as much as he had earned, okay, so on a breach of contract, the parties injured may be entitled to work done and services performed. A quantum merit claim is allowed as an alternative to damages if the benefit provided intended to be gracious. Example, not doing it for free, Section 71, Contracts Act 1950. If the contract does not stipulate an agreed sum to be made payable, actions and mission biofuels Manbahat 2014. Now, when someone cancels, okay, here's an example. Let's say you're a contractor fixing a house. Let's say the one that you're fixing, renovating. Let's say you're renovating a house, not fixing, renovating a house. Let's say you're doing it for your friend. Now, this can happen in a situation where you're like, I'm going to renovate the house and I don't know how much it will cost, but once we're done, then I'll tell you. Let's say your friend suddenly, like, let's say renovating requires 3 months and like 4 weeks into you renovating the house, decides that they don't want you to renovate the house, they want you gone. I don't know why, maybe you smell funny. So in that particular case, they will tell you to stop, which of course they can't do because they already hired you for renovating the house. This will be a breach of contract. You were supposed to be given 3 months and yada yada. Whatever. Let's say because you haven't decided how much the whole thing costs, you can ask for a quantum of merit, meaning you can claim for the amount of work you have done and the materials you have already used so far. Again, this sounds nice in theory, but you're never going to get the whole amount again. So if you're going to do some work for your friend, make sure he's a very trustworthy person. Okay, as for contract rescinded to the voidable nature of the contract, Section 65 CA Operates Contract Act. According to the Section 65, a person those option a contract is voidable rescinds it. The other party thereto need not perform any promise herein contained, which is the promiser. So in the situation where someone rescinds the contract because you may have void the contract for some certain reason, maybe you made a mistake, maybe you have done something they don't like, and they have the right to do so, you don't have to carry out the contract anymore. Obviously, this is what rescission is all about. Rescission, of course, no good. Congratulations to Bitcoin people who got a lot of money. Now, 80,000 I heard. Anyhow, that's a lot. At this time it's 80,000. I don't know what it is now. Okay, the party rescinding a voidable contract shall, if he has received any benefit under which any party such contract restore the benefit as far as it can be, a person to receive it. When an innocent party rescinds the contract is voided by him. We've already discussed this earlier, so I'm not going to discuss in such detail. You kind of already know it. Anyhow, I'll just recap it, and we'll pretty much end the lesson here. Section 66, Contract Act 1950 states, when a contract becomes void, any person receive any advantage in the agreement, contract is bound to restore it, and to make compensation, the person won't receive it. So whatever you already received prior to rescission of the contract, you should return. Like I said, remember the bash of football earlier. Remember my statement there. You can go back and take a look at that as well. If you have received the first bash, you have to return the first bash to the supplier of the football. And he, of course, returns any money you've already paid so far and money that he currently owes you as well. So that's all. My slides are done. Okay, so I hope this helps in your preparation for the exam. It's roughly 39 minutes, so I'm a bit under time, so I'm pretty happy about that. So good of luck, best of luck. I'm on a Saturday, so I'm wearing a bit informal clothing. So I'll see you guys when I see you. Best of luck on your exam, and I'll see you all later. Peace.